the right tools to do the right things to be able to help our clients. I just want to say I'm thrilled to be a part of this and want to do everything possible as the chair of the Continuum of Care to be supportive in this effort. And I'll throw the ball back to Laura. Thank you, Laura.
Thank you, Karen, for the support and from joining us in all these great activities we're able to provide our partners. I am going to go ahead and introduce our first speaker, Maria Cázares Reyes. She is from Inland County's Legal Services. She is the Practice Group Director. And I am going to go ahead and hand the mic over to her and let her begin her presentation. Thank you for being here, Maria. We really appreciate it.
Good morning, everyone. As stated, my name is Maria. I'm the Practice Group Director for the Housing Department. That is just a fancy way of saying managing attorney. So I manage our housing unit here with Inland County's Legal Services. So I do oversee all the projects that we do. So we'll be going over that today so everyone kind of knows what we do and what we're able to do. Next slide. So before we get started, I am here mostly representing the housing team since that is my practice group. But we have a lot of services that a lot of time they not conflict, but overlap with other practice areas. So for example, someone dealing with housing issues might also benefit from getting public benefits or health related information or even restraining orders. So I did want to provide the list of all the different practices in our organization. So we do have different practice groups that do bankruptcy, consumer law, education, family law or domestic violence, health law, my team, of course, immigration, public benefits, senior outreach, and systemic and impact litigation. Next slide. So some of our housing goals, obviously the tenant law is a big area of law. A lot of people think it feels small, but it's actually a lot of different legal issues that come up with legal tenancies. So we do assist and try to assist with all the different legal issues that come in our door, but our focus, 90% of what we do and all of our services are going to be focused around preventing homelessness. So more specific evictions. So any unlawful detainers that get filed, most of our services are tailored to assist primarily that kind of service. And then we do offer legal advice for anything else. We also do have a small practice for foreclosure. So we also, our next goal, not only prevent homelessness for tenants, but also making sure the homeowners are preserving their homes. This is a smaller area that we do. And I say that because we actually don't get a lot of clients calling us over these issues, or when they do, it's usually very last minute. So they're calling us saying, my house is getting sold in an auction tomorrow. So at that point, there's not much we could do. So usually we do assist with foreclosure, any advance notice. Hopefully they're calling us as soon as they receive a notice of default. But that is our primary two goals in the housing department. Next slide. So the main services that we're going to cover and as I'm going to mention a lot of times is, again, really focus on eviction work. So the main service that we offer in the housing department, which is majority of where we get all of our clients, is the hotline. So that is majority where 90% of our clients come in to get assisted with Inland County's legal services. Our housing hotline is open Monday to Friday from 9 a.m. to 4 p.m. with the exception of Fridays when we close at 1 p.m. For staff meetings. So in the housing hotline, it is composed mainly of paralegals that are being supervised by attorneys. This is going to be your situation with any legal issue comes in the door. They could call us regarding repairs, rent increases, definitely evictions, and then they're going to be given at a minimum legal advice over the phone. We have the UD clinic. This clinic is strictly for unlawful detainer answers. So if somebody gets served with an unlawful detainer, we are meeting clients first come, first serve to assist them with drafting an answer and a response to their unlawful detainer. And then we have TLAP, which stands for Tenant Landlord Assistance Program. And this is our court-based program. We are in court Monday to Friday, and we cover 8 different courthouses: Barstow, Fontana, Corona, Palm Springs, Joshua Tree, Marietta, Corona, maybe I mentioned it. But we cover basically most of the courthouses that hear evictions with the exception of Blythe. We don't cover that courthouse as a set schedule, but if somebody calls us and we're able to accommodate them, we might be willing to go out there. Next slide. So more specific with unlawful detainers, there is a lot that we do around unlawful detainers. The main goal, if we got everyone to call us in on time, is going to be to prevent them from even getting to this stage. So if they call us during the notice stage or even calling us even before the notice stage, we might be able to assist with other services that will hopefully prevent the landlord from even filing that eviction. But as soon as that eviction is filed, our priority is to give that priority to those clients. So once they get started with an unlawful detainer, at a minimum, like I said, they are going to be given legal advice. The legal advice will let the clients know this is what the notice is. This is what the landlord has to prove in order for you to either win or get evicted. In other cases, if they're able to send us their copy of the summons and complaint, then we're going to sign them up for our virtual clinic. We currently are still not having in-person UD clinics, so we are only having them virtually right now. So if the clients are able to send us a copy of the summons and complaint, then at that point, we're able to sign them up for one of our UD clinics. Like I mentioned before, it is first come, first serve, and that is because we service all of Riverside and San Bernardino counties. So we're and we're making sure that we have enough appointments, but obviously we're not able to meet the demand of everyone. If we're not able to draft their answers, then we do refer them to some of our partner agencies or self-help. But our goal is to be able to get their answers if they're calling us in time. And then when they are in court, we offer representation. So whether that be helping them stipulate, in some cases that's going to be probably the best thing for them, or we are proceeding to go to trial with them. The type of service is going to be dependent. Most of the time it is first come, first serve. We are there, and like I said, most of our 8 different courthouses, except for Blythe, we do show up at least half hour early before their trials, and that is when we start getting our clients. We are there, we send out an attorney and 1 paralegal, so they're making announcements. The courts allow us to do that, so we are there making announcements, so anyone who is there for an unlawful detainer trial could approach. If they qualify for our services, then that is when we're going to go through the process and advise them on what they could do, what they recommend that they do, and it's all dependent on their cases. For example, in Barstow, in Fontana, those are our busiest courthouses. So if you know of any client that is going to need that service, make sure that they know to show up early, because we cannot guarantee we're going to be able to help every single tenant there. So another thing that we do once we know, oh, sorry, if you could go back one. Yeah. So another service that we offer when we know our tenants are getting evicted is, especially when they're in the notice stage, is to draft reasonable accommodations for them. This is very specific to the client, and that is if we're able to find that there's a link in the nexus connected with the disability they have and with the reason they're getting evicted. We have been pretty successful. So some of the examples that I could provide you for this, we have assisted tenants that have, for example, either disability, a health-related issue. Sometimes they call us saying that they have cancer and will not be able to move out in 60 days. Depending on the plaintiff, we could file a reasonable accommodation and ask that they either be provided with additional time or give us more time for them to cure the defects that they're getting evicted for, based on those nexus to the disability that we are alleging. In some cases, we have prevented eviction. So for example, an example that I could provide you all is someone who's getting evicted for having a dog in their property. And based on the landlord's agreement, you're not allowed to have pets. Well, if there's a nexus between an emotional support dog or the need for having a dog, you could make a request to the landlord to bend those rules for you. In that situation, we actually do those a lot, and we are preventing evictions. So the landlord accepts our reasonable accommodation for the tenant, proceeds to then waive their notice to have the tenant move out. So those are powerful in preventing that lawful detainer. That is an example of our goal to not even make it to court. Because once they're in court and once that lawful detainer gets filed, then it's up to the judge. So what we're trying to do when we are assisting them before the lawful detainer is let's not leave it up to the judge. Let's take some control and have you move out if you decide to on your own terms. Another area that we do assist with, and this one we kind of don't have too much control to do much, and it's unfortunate. So we are continuously trying to advocate is illegal lockouts. Sometimes the landlords are evicting tenants without giving them the due process. In this situation, the reason why our hands are often tied is because we do rely and need the assistance of the sheriff's office or police officers that are being called to go out. Sometimes the police officers or sheriffs that they don't want to get involved. So a lot of times they're telling clients, this is a civil matter. I'm not allowed to get involved. So you're going to have to go to civil court. And that is unfortunate because the process for a tenant to go to court and as the judge to file an injunction is actually very difficult. What should be happening is that the landlord should be told that they're not allowed to evict someone without a formal unlawful detainer process. So if we do have those situations, we try to help them as much as possible. But a lot of times it is a little bit difficult with our resources. Next slide. So like I mentioned before, we do have a small practice for homeowners as well. So we do get homeowners calling us saying that they're either going to be facing foreclosure or are already in the foreclosure process. And when we say that someone is already in the foreclosure process, that it usually starts with any notice telling the homeowner you are behind 90 days, you are behind in this amount of payments. If you don't pay us, we're going to initiate the process. The notice of default is really what starts this foreclosure process for homeowners. This is the stage that we want to get our clients. So if somebody's calling us for foreclosure assistance, the notice of default is where we might be able to do more for them than if they're calling us saying that they receive a notice of their auction and it's happening this weekend. So that gives us less ability to actually assist and preventing losing their home. Otherwise, we still will offer at a minimum legal advice, let them know what's going on, let them know why they're losing their home, in times what they might be able to do to stop the auction from happening, but it's very limited as to what we could do for them at that process because it is a pretty complex situation, more difficult than doing an eviction. So if you know anyone that is facing foreclosure or might be, the earlier they call us, the more we might be able to do for them. Loss mitigation is another form of home ownership services that we offer. This will be similar to what we offer for unlawful detainers and trying to prevent them from even going into foreclosure. So this is why it's important if we get them at the early stages. If we already know someone is behind in their mortgage payment and they're not going to be able to make that payment, instead of waiting for them to be in the foreclosure stage, we could assist them with doing asking for a forbearance, a payment plan, sometimes seeking a modification, very dependent to their case. So if we don't think they might qualify for some of those options, then we might advise them to do other things depending on their situation. But this is really where we want to get our clients is loss mitigation. How can we prevent you from even getting to the point where you might be at risk of losing your home? In some cases, unfortunately, we're not successful, or if the client is calling us a little bit too late and they do end up losing their home, then we also assist former homeowners and their eviction process. So if they are already getting evicted because the bank took over the home, there's a new owner, then we also will assist them with the whole process of the unlawful detainer, just like we would for a tenant. Next slide. So another area of law that we do is subsidized housing. This is going to be your cases where someone needs assistance with paying a reduced amount of rent. We do not assist with actually looking for housing. That is a lot of times we get people referred to us, or people calling us thinking that since we do housing law that we might be able to actually assist them in applying. We don't offer that service, just in case there's still some confusion. But what we could do is if sign them up to see if they could potentially get some kind of reduced rent. Depending on the county, some of them do have a long waiting list, but there are other programs, not just Section 8. That is the most popular one most people know of, but there are other houses like low income tax credit housing, for example, that might be offering tenants reduced rent. So if that is something that we think a client might qualify for, then we are going to assist them with applying for subsidies and signing them up for those. We also assist with termination of subsidies. So it's someone that, for example, has a Section 8 voucher, if they're at risk of losing it because either they violated a lease agreement, or because the landlord made false accusations against them, then we're going to assist them with trying to fight that termination. And we have been quite successful. We have one of our a paralegal and attorneys that have been doing this work for a while, very experienced, and they work well with the counties. So they usually get great success for us clients, especially with their merit. So if you do know someone that has a subsidy and might be at risk of losing it, make sure you're sending them our way. Also very important is clients that are in Section 8 or one of those subsidies that are facing eviction. We also really want to get those clients early on, because once they're in the unlawful detainer stage, they're also at risk of losing their subsidy. So it's very important that as early as possible, if anyone is in this situation, that we assist them early on to make sure that they're protected, not just their housing, but also their subsidy, which is oftentimes very important, especially right now that the rents are going that are pretty high, and people are having difficulty finding places to rent. And I believe that might be the last slide. Yeah. So I did want to leave some time to discuss any questions you all might have. So I am more interested to see any questions you have for us. If you do want to refer any clients over to us, the best way to do it is for them to call the hotline. The number's here, 888-245-4257. Again, we are opening the hotline 9 all the way to 4 p.m., Monday to Thursday, and then on Fridays, 9 to 1. I do recommend, especially if you're going to be referring people over to us, that they call in as soon as 9 a.m. That is, they're almost guaranteed to get a call right away. We do get busier as the day goes on. We're the busiest around 11 to 12. So keep that in mind. Sometimes, especially right now, we do have high volume of calls. So people might be waiting for an answer anywhere from an hour, half hour to an hour, hopefully not more than an hour, but depending on how many calls we are getting during the day, it might take them a while. So if they want to call us, the earlier, the better. And I do see questions. I believe the first hand that went up is Karen.
Yes, excellent presentation. Thank you so much. I have 2 questions for you. The first is, if you could, just off the top of your head, let us know what like the 3 to 5 top causes for evictions are. I can tell you just a trend that we're seeing is a lot of rental units being sold out from other people, and they can't find a place to go, so they're being evicted because of a sale. But just for us to understand gaps in the system, that would be great for you just to say what you're seeing as like the common theme again and again, why people are getting evicted. And then also how you think that the continuum of care can help. I know that the cost of housing is big. It just some of the best practices that you've seen in different cities or programs that are working, but there's just not enough of it. Tell us what you think our system needs more of to as a stopgap.
Yeah, so the main thing that we are seeing, especially now after the COVID-19 protections pretty much ended, that the main cost that people are getting evicted is non-payment of rent. So that is majority of the cases we see, especially Some of you might know, but there's no real protections for rent that became due after April 2020, for example. So we are starting to see a lot of those cases. We have clients that might apply for rental assistance for anything before March 2022, but as soon as they're behind in April's rent, the landlord could proceed with eviction with no protections, other than the formal ones that we know. They have 3 days pay or quit. If they don't pay in those 3 days, they could proceed with eviction. So that is majority of the cases we're seeing right now. The second one is actually in very difficult to prove, retaliation. So any that the tenant asserting some kind of right, whether it be asking for repairs, fighting back rent increases that were improper, even not paying rent during the COVID-19 protected period. So those situations usually the landlords are just giving the 6-day notice, in some cases with providing the cost, in some cases not providing the cost, depending on whether they have to. So I think that will be the second one. And like I said, harder to prove because usually the landlords, but at this point, they're going to deny that is retaliation and they'll give us a reason. And the third one, just like you mentioned, it is selling the homes. We actually, and we do work closely with the plaintiff's attorneys. It works best for us. It's usually the same plaintiff's attorneys that we see in court every single day. They usually cover the same courthouses, and even hearing from conversations from them, a lot of their clients are choosing to sell the homes because what they see is that there are becoming more, there's more tenant protection. So they're kind of, I don't want to say they don't want to deal with it, but there is a hesitancy to continue on being a landlord with there's so many protections. So that will be your third reason. As far as it's difficult to know how to stop this more than I think, especially when we get clients coming in for anything other than we're selling the home, is education. It will be something that's very important. There's a lot of misunderstanding and a lot of misconceptions in the community. We still get clients, for example, and I'll give you an example to tell you why I think education is a big key. And that is that we still get a lot of clients calling in saying, well, the landlord cannot proceed with an eviction before June 30th, which now is today, but before we were getting this calls a month ago, 2 months ago, and that's completely false. That is a very small area that the statute protects as far as who wasn't going to proceed with eviction before 6/30th, and anything else could proceed. So 6-day notice, we're going to proceed. A 3-day notice, pay rent or quit given after March 2022, we're going to proceed. And the tenants, a lot of the tenants, all they heard was they cannot evict me before June 30th. So a lot of the evictions they're fighting in court is because tenants really thought they had these protections and they were fighting for the protections and those rights that they thought they had, which they did not. So I'm going to, education, obviously more affordable housing, but that is a little bit maybe outside of our control. Hopefully we could build more affordable housing and that would, it won't fix the issue, but I think it will really help a lot of tenants.
Thank you.
Yes, thank you, Maria, for that. We do have Eddie Ortiz with his hand up. Go ahead, Eddie.
Hi, how you doing, folks? Can you hear me okay?
We can hear you.
All right, I'm Eddie Ortiz. I'm one of the navigator outreach here at Valley Restart in Hemet. I have a question. If someone has already applied for the United Lift program, rental assistance, and they're already in the conditionally approved, which right after that, a payment gets made, and they've done it before April or something, because I run into a lot to where people are, coming here saying, do we apply rental assistance, this, but that's what they're running into. Landlords are still going through the eviction process because they applied for the rental assistance at United Lift, and it goes through review, conditionally approved, and then it goes to the final stage of payment. If it's in the conditionally approved and about to be paid, can the landlord still go through with the whole eviction process and everything, even though they are promised to get paid and the landlord has agreed with the program and they know it's a waiting process?
So there's, I'm going to give you the attorney response that everybody hates, and that is it depends. Because not only is every judge different, so obviously for us when we're assisting the tenant, we're in the tenant side, we're fighting for all this, but we get different responses and different opinions from judges. The process that we argue is should be proper is that if someone is getting evicted for anything before April 2022, so that is the key. If they got a 3-day notice April 3rd, for example, then they're not necessarily protected. The argument will be that the landlord already got paid if we could prove that. But as far as our rental assistance and proving that was approved, if it's anything before April, then that is the arguments we're making is this person got approved. The statute, the way it should be followed is that the judge shouldn't proceed with the judgment. Instead, we should get a continued hearing in order to come back and see what's a update on it. So we do have a lot of cases, for example, that are still pending. We got to court and we got in continuance at least 3 or 4 times, and we keep coming back because the money hasn't been paid out. So that before we could get that case dismissed, and some landlords are on their own dismissing cases. So that is I'll give them a lot of credit for those landlords that are doing it on their own. Otherwise, we have to keep fighting and coming back to court to show the judge that it's still pending. It hasn't been denied. And once it does get paid out, then the judge will dismiss the case. That is the process that we argue should be followed. We don't always get that success every time. So we could potentially have a judge that says, and it also depends, that we'll add it, what you could prove. So if a tenant shows up in court and says, I got approved or have a conditional sentence, we will argue that the court should follow up, but they don't always. So essentially they could be entering a judgment against the tenant. And then there is luckily the UD 125, which is a form that allows tenants to file with the court if they, especially in cases where the landlord was paid before the lockout, or to prove that they already got approved for the rental assistance before for anything covering April 2022. But that alone, just everything I said is how confusing it is. It really depends case by case. Ideally, the argument that we always make when we are assisting the tenant is obviously the statute was meant to prevent the eviction from happening when there's to fight. It's not an automatic thing.
Yeah, for sure. I talked to a representative at the United Lift, and they stated if anyone does have any type of court documents, that they're to submit that to the United Lift, and they can pull the application quicker and try to get a payment quicker to the landlord before the court proceedings. I just wanted to share that in case anybody needed that information.
Yeah, and that's important. And what's unfortunate and fortunate is like I did mention, especially with our UD trials, we're getting our clients the same day of. So that's what makes it sometimes difficult is we are getting the tenant essentially approach us, and that's the same day that we're about to do the trial. So what we have, and we do try calling a lot of the rental assistance programs to see if they could email us something in the moment, but that's a little bit more difficult. So luckily we do have the UD 125% form, which allows the tenant to come back to court to prove it. But it is something, like I said, that we're still fighting and hope, and we're not always successful in all the cases. It depends on the judge.
For sure. Thank you for your time. That's a lot of good info. Thank you much.
No problem.
Thank you, guys.
Thank you. Thank you so much, Maria and Eddie, for the great question. Hi, everyone. If you guys haven't heard of me, my name is Monique Guerra. I'm the Homeless Youth Coordinator with Riverside County's Continuum of Care, and I will be facilitating your Multidisciplinary Approach series webinars from now on. So hello, everyone. We're trying to get all of our logistics and make sure our amazing presenters are good to go. Craig from Fair Housing Council, are you on? Thought I saw you in the participants. So if you have any further questions for Maria, please go ahead and put them in the chat, and then we'll see if we have time afterwards. And also if you need her information, please, Maria, if you want to maybe share your email in the chat as well. Yay! So it looks like, Craig, you are on.
Hello.
Oh, there he goes. Okay. I couldn't hear him, but I can hear him now. Go ahead, Craig.
Good morning, everyone. I'm Craig Oliver with Fair Housing Council of Riverside County, and thank you so much for inviting us to share today. Now, the Fair Housing Council of Riverside County, the main objective is to ensure that there's no discrimination in the sale, rental, or financing of housing throughout the county. And we do this, of course, ensuring that those protected classes are not being discriminated against. Originally, age, national origin, religion, color, and race. Now, we serve the entire county in this pledge. The city of Moreno Valley, we hold a fully staffed office. We also have an office in the Palm Springs area that handles all of the desert in Eastern County out there. And we have a full service office in Moreno Valley. Corona, we have a satellite office as we do in Paris. So we go out to the people so that they don't have to come down to downtown Riverside in order to get services. So what do we do? Well, we receive and investigate housing discrimination complaints and attempt to resolve these complaints either by referring them to HUD, Department of Fair Employment and Housing, or to a private attorney, and conduct webinars and seminars in order to make sure that people are aware of their rights, can't enforce or exercise your rights if you're not aware of them. A large part of what we do is to mediate landlord-tenant disputes. By receiving, investigating, and mediating these disputes, always maintaining tenancy whenever possible. Things like evictions, repairs, harassment, several different issues that landlords and tenants tend to bump heads about. Landlords and tenants are free to call us at any time if they're not clear about how to proceed. So when we receive these calls, we have to determine, is this a landlord-tenant dispute or is this a discrimination case? Not always easy to determine, so we have to ask additional questions to make sure. Why do you think they're treating you this way? Is everyone being treated the same way? If not, that's the definition of discrimination, differential treatment when all other factors are considered the same or similar. We also do pre and post-purchase counseling programs. We have a dynamic first-time homebuyers seminar. It's an 8-hour workshop where if they complete the workshop, then it makes them eligible for free down payment assistance, money they don't have to pay back as long as that's their primary residence. We also do loss mitigation counseling, which is just another word for foreclosure prevention. Make sure they're aware of their options for deeds of lieu or other issues like ways to get out of that situation or dealing with their lender so that they don't lose their down payment or that they don't lose their equity, short sales, these kind of things, in order to help them move on while maintaining their investment. And we do a lot of credit counseling, ways to prepare people for the challenges of home ownership. We are the ones who do administrative hearings for the Section 8 programs. If someone is about to lose their housing authority benefits, we do the hearings because that way they know it's fair. We don't have an investment one way or the other. So just as a little bit of background, the Fair Housing Act came about in 1968 in the throes of the Martin Luther King assassination and other landmark legislation, the Civil Rights Act, Voting Rights Act, basically saying that no one can be discriminated against on the basis of those 5 protected classes we talked about. 20 years later, in 1988, the Fair Housing Act was amended to add 2 additional protected classes. Those protected classes were disabled, and familial status. Familial status being the presence of children or pregnant women. You know, sometimes you get landlords who don't want to rent to people with children. They, you know, you got these 4 rugrats, we're not going to let you rent my house, pouring syrup in the carpet and crayons all over the walls. But of course, kids got to live somewhere, right? So there's no such thing as adult-only complexes anymore, except if they're for the elderly, 55 or 62 and over. These amendments gave the Fair Housing Act a lot more teeth and brought about a lot more cases because of the disabled and family status, taking it from just conciliation to actual prosecution of these classes, of these cases. But we said that there were protected classes that we deal with. The original ones, race, color, religion, sex, and national origin. And as we said, in 1988, the 2 additional classes came about, disability and familial status. When we talk about discrimination, oftentimes people think about, well, blacks and whites, just given the nature, the history of the country. But the fact of the matter is, about 70% of the discrimination cases filed have nothing to do with race, actually. They're about disability. Disability usually centered around reasonable accommodations and reasonable modifications to allow disabled to enjoy the property. I'm going to move ahead here. Okay, so housing discrimination, what is it? Differential treatment when other factors are the same or similar. What are some examples of that? Refusing to rent or sell housing, denying that a dwelling is available, steering. Steering, of course, is the idea of guiding a potential renter or a buyer toward a certain location or a certain type of housing. For example, you might want to look at the complex down the road a little bit. There are a lot more kids over there, and your kids can make friends with them. Plus, we kind of like it a little more quiet up here. So steering towards a particular part of the complex. We also deal with a lot of domestic violence cases. A lot of times with domestic violence, those that are victims often need to make moves very quickly and decisively. And in order to do that, they need the assistance of the landlord. Why do they need the assistance of the landlord? Well, they may need to get the locks changed on the doors. They may need to get out of the lease immediately and not be held to that lease because they need to relocate. They may need to have the perpetrator evicted, even if the perpetrator lives there with the victim. And there are certain things that have to be in place. For example, the victims of domestic violence have to have either a restraining order or a police report to prove that they are victims. And if they're not able to present these, if they don't have a restraining order, then they can't expect for the landlord to keep that person, the perpetrator, off of the property. And they're not able to claim victims of domestic violence, VAWA, which is the laws that protect them from being evicted because of the illegal deeds of the perpetrator. We talked a little bit about disability and accommodation for the disabled. Reasonable accommodations for the disabled. Reasonable accommodation is basically a change in the rules or policies that allow someone disabled in order to enjoy the property. And there are many examples of this. For example, allowing them to have a service animal when there is a no pet policy. And if they're allowed to have the animal, they cannot be charged a pet deposit like they would in a general case, because the animal is not a pet, it's a necessity. Or changing the date that the rent is due. Just to give you one quick example, someone gets their disability check from the SSI on the 8th of every month. Comes just like clockwork, comes on the 8th of every month. But the landlord wants their money on the 5th, by the 5th. And if you don't pay by the 5th of the month, you get a $50 late fee. So the disabled person ends up paying a late fee every month, 50, 50, 50, month after month, year after year. With a reasonable accommodation, they could simply have their due date changed, change the date that the rent is due to the 8th, so that there's no need to pay the late fee. This is reasonable. Now, the only way that a landlord can deny a reasonable accommodation is if it causes an administrative or financial hardship to grant that accommodation. And clearly it's not going to cost them any manpower or any money just to change a due date. They know the rent is coming on the 8th, just like it has for the last several years. So that's reasonable accommodations. Reasonable modifications, a modification is the change in the physical makeup of the property, like putting in grab bars to get in and out of the bathtub, or widening the doorways to get the wheelchair through. These are modifications. So a big question generally becomes, well, who pays for this? In the general case, it's the tenant who will pay for it. They would put some money in an escrow bearing account so that the property can be reverted back to the original condition once the disabled tenant moves out. But of course, the landlord is free to leave it in that way, disabled ready. They can advertise it as being disabled ready, which is a big benefit to everybody. We talked about some modifications and so forth. And we talked about service animals. There's been some confusion as of late as to what is a service animal as compared with an emotional support or a companion animal. For the purposes of our conversation today, it suffices to say that a service animal is an animal that's been trained to do something. It's been trained to do something specific for the disabled person. The most common is what we know as the seeing eye dogs that help people with blinds. As we know, these animals can walk up to you, take a sniff of you, and know that you're about to have a seizure before you know. So an assistance or emotional support animal does not necessarily be trained to do anything in particular, but just provides, as it says, emotional support. As long as there's a doctor, therapist, social worker, someone who knows about the disability and the kinds of limitations that it puts on the dweller, they're able to say that this person needs the animal. If they're able to provide that kind of documentation, then in most cases, the landlord must allow the service animal. And same with a personal care attendant. What happens here a lot of times is if there's someone living in to assist with a disability, the landlord will want to charge a little extra, say, that person lives here, so I'm going to raise the rent another $200. Well, the personal care attendant is not a tenant, they're a necessity. And the person needs this attendant in order to enjoy the property. So they're not able to impose any additional costs for that person to live there. And again, as long as the medical professional has said that they need this kind of attendant. And we deal with accessibility issues a lot as well. For example, we have to have light switches that are in reach of someone in the wheelchair, and electrical plugs not too high and not too low so they're able to access them. Kitchens and bathrooms where they can maneuver in the wheelchair and be able to enjoy the property. So that's accessibility. Reinforced walls so that the grab bars are strong enough to support the person getting in and out of the bathtub. These are accessibility requirements that are particularly important. And of course, advertising is very important as well. You often see advertising that talks about we only want active senior living. Well, what does that mean? Or professionals only, or no kids allowed to play here. To say that there are no kids allowed to play here or no kids can ride their bikes here, that's discrimination against familial status, the presence of children. What they should be saying is that no one can ride their skateboards here, not just no kids. And of course, we have the Fair Housing logo that we encourage all housing professionals to post. That's their face to the community that says, we're interested in playing fair and dealing with and passing on the fair housing rights to everyone who comes up to us. So we encourage them to have that in a conspicuous place on the walls, or a fair housing logo actually on their application. So we do a lot of fair housing testing as well, which is where we go out, pretend to be renters or looking for financing, just to see how people are treated. And then we can record the interaction. Well, did they offer you a handshake when you came in? Did they offer you an application, or did you have to ask for one? When they showed you the unit, was it the one in the back overlooking the dumpster, or was it the one in the front overlooking the swimming pool? Did they show you the amenities, the pool, the jacuzzi, the tennis courts? Did they talk about them, or did they actually walk you around and show them to you? And we simply can compare the two interactions because we've given them a profile. The first person we sent in had 2 children. They were looking for a 2-bedroom apartment. The other person had no children, but they have the same profile. They make the same amount of money. They have the same FICO score. Everything is similar except the fact that one has children and one doesn't. And we can compare them side by side and just check it off. And if they're being treated differently, then we know there's an issue. So these are the kinds of ways that we ensure that there's no discrimination going on in the sale, rental, or financing of housing within the county. That's fair housing for Riverside County. That's who we are. That's what we do. Thank you so much.
Thank you so much, Greg, for that presentation. And we have about 5 minutes left if anyone wants to ask Greg any questions at this time. Kimberly, I think I saw your hand up. Did you have a question for Greg?
Hi, I did have a question. So I just want to be clear. So if there are any violations of any of the things that the things that you stand behind are experienced by any of our members, they can contact Fair Housing and Fair Housing will investigate it, or what's the follow-up to the complaint?
Well, if we are contacted and they feel they've been discriminated, again, like I was saying earlier, a lot of times they start off as landlord-tenant disputes. And so we'll have to ask some follow-up questions to determine, is everyone being treated this way? Is the manager just a rough person who likes no one, talks bad to everyone? Or is it just you? And if so, why do you think that is? Well, I don't know. Why do you think it might be? Well, we did have this or that situation. And once we determine that it may be a discrimination case, then we would collect more information. Again, we may go out and do a test on the facility with someone. For example, if it's race, we'll have pair people up and give them a profile, go out and see if there's differential treatment, or we can refer it to HUD or DFEH or a private attorney to follow up with the case. And generally, once we file a case, it's investigated and dealt with through that whichever agency we refer it to.
So
But
you file a case on behalf of our member.
on behalf of the complainant, that's correct.
Okay. Okay. Thank you for that.
Yeah, we're the ones to contact. If you ever suspect there's any discrimination going on, we're the ones to contact.
And so in the past, we've had members that complain of like black mold and things like that. And the landlord not addressing it. Is that also a case for fair housing?
That's a very good question, and I'm glad you asked it. With mold, asbestos,
Health hazards in general?
infestation of different types, roaches, rats, these kind of things.
Mhm.
Generally, we try to, if the landlord is not responsive, because these are health and safety violations, as you can understand.
Yes.
If the landlord is either unwilling or unable and is ignoring the issue, after there's evidence the landlord is aware of it, is not dealing with it, generally we'll deal with environmental control or the code enforcement. We would have county code enforcement come out and inspect and verify that there's actually a violation there, a health and safety violation.
But does the member start with you, or would they, like if they were to call us and have those complaints, would we reach out to code enforcement or environmental safety, or would we start with fair housing?
Start with fair housing.
Okay.
Yeah, because we would contact the landlord or the property management, make sure that they are aware of the issue and see if they have a plan to address it. If they do not address it, then we would let them know, well, if this is not dealt with in a timely manner, we're going to bring in code enforcement to deal with the issue. At that point, they'll issue a violation notice, give the landlord or management a chance to correct the violation. If not, they'll give them fines and so forth, and they'll take it from there. But we try to have it resolved before we bring in the county agency. But a lot of times we would want to bring in code enforcement anyway, because it's one thing for a tenant to say that, look, I've got this infestation problem, or there's a mold issue, or an asbestos issue. It's one thing for them to say it, quite another to have a county agency verify it on their behalf.
Yeah, I agree. Okay, thank you so much for your detailed answer. I appreciate that.
You're quite welcome. Anybody else? Anybody? Thank you so much for your time.
Thank you so much, Craig. And thank you all who are on here. I will send a follow-up meeting email with the recording for today's webinar, as well as we'll share the slides. So please look out for my email. Our next webinar will be July 21st, and we'll go ahead and send out more details about our next webinar here soon. So thank you all for coming. Hope everyone got some really good info that you can take back to your organization and agencies, and just keep doing the good work that you all do. So thank you all so much. We'll see you next time. Bye.
Thank you. Bye-bye.
Thank you all.
Thanks again, you guys. I hope you have a great day.
Thank you.
And you too. Thank you for being here. We appreciate it.
Appreciate you guys. Bye.
Do I have to download attendance or anything?
I don't think we track attendance, but I know the recording. Oh, we can stop the recording. Can you
Yeah. How do I
click up on the top?
stop recording? Got it.